Colleagues, I wonder if we could get started shortly. I know that you've come from a very animated luncheon, but hopefully that spirit of animation and discussion will continue. My name is Bob Ray. I'm the Vice President of the Assembly of States Parties based in New York, and it's a great pleasure and privilege for me to be here. I think we all agree that we've had a very stimulating start of the day. And we're going to have a panel. Each panel is going to last for about an hour, a little under an hour. So I say this to my fellow panelists. If they start speaking for an hour, that might suggest that they share the platform with somebody else, so that we'll have a chance to do that. We have a very distinguished panel, of course. And I'd like to introduce everyone to you. On my left is Catherine Marchi-Huel, who's the head of the International Impartial and Independent Mechanism on Syria, better known as the IIIM. We have Dapo Akande, who's a professor at Oxford University, and we were discussing, he's just become a titulae professor of international law at the University of Oxford. Anta Guisset, who's counsel for the defense, une femme qui a beaucoup d'expérience dans le domaine de...
She's a woman who has a lot of experience in how the court works and exactly how to provide the necessary defense for those accused.
Katarina Trendafilova, who is going to be speaking to us as well. The purpose of today's session, well, the purpose will be decided by the panelists, basically, not by the moderator. But the purpose of the panel today is really to start to connect the dots and to look a little more specifically at some of the things that need to change. I think we have come away from the morning with a sense that we have accomplished a great deal in 25 years. But I think we also recognize that, like one of those medieval cathedrals, you get started in 25 years, but you don't build the whole building. So there's a lot of more building that needs to be done. And I think we want to get into some of the discussion today about informally and among friends of the court and those who've been active in the court to get a sense of what more is it possible for us to think about in the years ahead. So let me start without any delay. Je me tourne d'abord vers Madame.
I will first turn to Ms. Catherine Marchi-Huel, who's a French judge and has been since 2017 and head of the mechanism tasked with serious crimes committed in Syria, the IIIM. She has years of experience in the legal realm and in the civil service, including within the United Nations, working on criminal justice, transitional justice, and human rights. Since 2015, she has been a mediator for the Committee of the Security Council for Daesh, Al-Qaeda, and other groups and persons and entities covered under that. Before, she was a judge in France and an international judge within the United Nations interim mission in Kosovo and in the extraordinary chambers within the Cambodian tribunals. She was a jurist and head of legal services at the chambers of the International Criminal Courts for the ex-Yugoslavia. She also worked in the French Ministry of Foreign Affairs in a legal role and within United Nations peacekeeping missions. Before this role, she was a jurist at the International Criminal Tribunal for ex-Yugoslavia before becoming an international judge on Kosovo between 2000 and 2008. Madam, it's a real pleasure to see you, and I give you the floor. Thank you, sir.
Gentlemen, let me first start by thanking the Assembly of State Party of the ICC for this timely event. I really welcome the opportunity to take a forward-looking perspective at the international justice ecosystem as a whole. This ecosystem has been fast evolving over the past 25 years, and there have been some frustrations, but also many achievements which we can continue to build on. The IIIM, with its justice facilitating role, has been in the privileged position of connecting effectively many of the various accountability actors on Syria. And as you will recall, the IIIM was created in December 2016 to assist in the investigation and prosecution of core international crimes committed in Syria since March 2011. The blockage of the Security Council regarding a possible referral to the ICC of the Syria situation became, in fact, an incubator for a new kind of accountability mandate granted in our case by the General Assembly and closely inspired by the principle of complementarity at the core of the Rome Statute. The mechanism has a mandate to collect, consolidate, preserve, and analyze information and evidence of core international crimes and to prepare case files for national, regional, and international courts and tribunals that have or may have in the future jurisdiction, including one day, we hope, the ICC. For the purposes of today's discussion, I'd like to make 4 brief observations drawn from our work in the Syrian context. They reflect how we and others have been connecting the dots on accountability in Syria as effective and constructive forces of the international justice ecosystem. First, the importance of seizing all available and meaningful justice opportunities. This is a premise. International justice is generally called upon when there is an insufficiency of effective justice opportunities at domestic level. And it's rare or even unheard of that this insufficiency can be fully addressed at the international level. We therefore have to pursue every justice opportunity that is likely to offer a meaningful perspective for accountability and justice in the eyes of victims and survivors of core international crimes. This can be done collectively, only be done collectively, with all part of the ecosystem playing their role, as I would like to illustrate in my following points. Second, the crucial role of national war crimes units. Since the adoption of the Rome Statute, many member states have built dedicated war crimes units and made increasing use of universal and extended forms of extraterritorial jurisdiction. These national jurisdictions are where most core international crimes are being judged today. In our work on Syria alone, we are currently serving some 15 competent jurisdictions that have made recourse to us with almost 300 requests for assistance relating to over 200 distinct investigations that all relate to core international crimes committed in Syria. Syria was also the first situation for which National War Crimes Unit formed joint investigative teams and UN investigative mechanisms like the IIIM and UNITAD support their joint investigation on core international crimes committed by members of Daesh. This approach is now also applied in the situation in Ukraine, and it involves the ICC. Third, the central role of civil society, including the crucial role of victims and survivors themselves. Around 2/3 of our 85 existing cooperation frameworks are with civil society actors, and we are in contact with many more. CSOs are our most important sources of information, starting with the trove of documentation preserved in our central repository. They are able to access important witnesses and territories to which we have ourselves no access. CSOs are making important contributions to ensuring the most strategic approach to our structural investigation and filling gaps in our central repository. Cooperation and coordination with CSOs is therefore central in our work, and this happens not only bilaterally, but also in our multilateral convenings under the Lausanne platform and our more recent accountability workshops. Moreover, our work is based on a fundamental victim survivor-centered approach, which recognizes that first and foremost, justice processes are for the benefit of those affected and should be informed by their needs and priorities. I already mentioned the importance of seizing all available meaningful justice opportunities. Victims and survivors are key in helping us to make that determination. We consulted them when developing our strategies on gender and our strategy on crime against and affecting children and youth. And we consult them regularly to present our approaches, our strategic lines of inquiries, and upcoming justice opportunities to hear their views on where priority opportunities for our limited resources might exist. And finally, and fourthly, it's to stress the multiplicity of justice opportunities and the importance of cooperation and coordination among accountability actors. There is a number of important opportunities on the horizon, and they may go beyond actual criminal justice proceedings. Most notably for Syria, we have, of course, now the joint application filed by Canada and the Netherlands before the International Court of Justice, alleging violations by Syria on the Convention Against Torture. And we are preparing to provide support for the ICJ case. This is a crucial case for many victim survivors of core international crimes in Syria. Going forward, we can imagine that certain parties could successfully sue the ICC prosecutor, for instance, for crimes committed in Syria and in part on the territory of a state party to the Rome Statute. And of course, from the Syrian perspective, efforts related to human rights reporting, transitional justice, as well as clarifying the fate of missing persons remain indispensable for victims and survivors. It's been our experience of the past 5 years at the IIIM that international investigative mechanism can offer a particular contribution in connecting many of these dots. Over the last 25 years, we have more and more realized what comprehensive accountability is likely to look like in a fragmented multilateral arena with considerable geopolitical divisions on various accountability files. In such context, accountability has proven to work as an equally complex ecosystem. It involves multiple justice actors spanning across a wide range of national, regional, and international entities and structures. I'm personally encouraged by the increasing number of states that are fully embracing complementarity and making use of universal jurisdiction, not only for alleged perpetrators residing in their territories, but also for those individuals most responsible who consider themselves far beyond the reach of criminal justice. Such investigations and ongoing cases send a first message of hope to victim communities that impunity is temporary. It encourages those documenting atrocity firsthand to keep going. It influences other political decision makers to follow their lead. I thank you.
Thank you so much, Catherine. It's a pleasure to hear you. I must say that in my time in New York, the mornings I spend with you when you come to see me are always enlightening, and you've shown that again today, I think, with your presentation. I think you're forcing us to think through carefully how this architecture is evolving. Dapo, you're next. It's my pleasure to introduce Dapo just once again. He's now the Chichely Professor of Public International Law at the University of Oxford, a member of the United Nations International Law Commission, a barrister at Essex Court Chambers, and most recently, he just told me, a fellow of All Souls College. He's acted as advocate, counsel, or advisor in many, many cases before international tribunals, including the ICJ, the International Tribunal for the Law of the Sea, the European Court of Human Rights, the World Trade Organization, and the International Criminal Court. He is an author. He's one of the editors of the scholarly blog Egyl Talk, and has served on the editorial boards of several leading international law journals. And he continues to provide advice on international law issues to states, international organizations, and civil society organizations. Professor Okande, we're in your hands.
Thank you very much, Ambassador Ray, and thank you so much to the ASP and to the organizers for inviting me to speak. Now, the focus of this panel is a recognition of the proposition that if effective accountability for international crimes is to happen, this will, in almost all cases, require efforts at multiple levels. Some crimes will be prosecuted before international tribunals such as the ICC, but there will also be a need for accountability in the domestic courts of either the state where the crimes occurred or perhaps also in foreign domestic courts exercising universal jurisdiction. and the principle of complementarity, which I know some of my fellow panelists will speak about later on, as reflected in the Rome Statute, reflects this principle of accountability at various levels. The question, however, also arises, and this is what I want to focus on whether we sometimes need a division of labor amongst international tribunals too. And I think this raises two questions that I want to focus on. So first of all, does the creation of the ICC obviate the need for the establishment of other tribunals at the international level? And then second, to the extent that other international criminal tribunals are created or exist, what should the relationship be between those tribunals and the ICC? So to start with the first question, it's obvious to note that the goal of the ICC, perhaps one of its most important accomplishments, was to create a tribunal which is permanent and one which would potentially have universal jurisdiction. And the goal of that, the point was that to ensure that the international community would no longer need to resort to ad hoc tribunals with jurisdiction over particular situations of the kind that we saw for the former Yugoslavia and Rwanda. And of course, the ingenuity of the statute was that in cases where the relevant states hadn't become parties to the ICC statute, either the Security Council or perhaps even a particular state could refer the situation to the ICC in that particular situation. And we've seen both of these things happen. Having said all of this, despite the creation of the ICC, we have continued to hear calls for the creation of international or internationalized tribunals for the prosecution of international crimes that have occurred in particular situations. And there are perhaps two main reasons why other international tribunals may be needed. So first, there may be situations that call for accountability today, which relate to crimes that for one reason or another fall outside of the jurisdiction of the ICC. Of course, after the adoption of the Rome Statute, we saw the creation of the Special Court for Sierra Leone, the Special Tribunal for Lebanon, extraordinary chambers in the Court of Cambodia, all of which dealt with crimes that were in part outside of the jurisdiction of the ICC, either because of the temporal jurisdiction of the court or in some cases because the crimes in particular, subject matter, were outside the jurisdiction of the ICC. And so the question that really arises is, what do we do in circumstances where the relevant states have not accepted the jurisdiction of the ICC, or where it has proved impossible to get the Security Council to refer a situation to the ICC? Should we just rely on national courts, where, again, the same problems of impunity that led to the ICC may rear their ugly heads, or should we, on occasion, have recourse to other international tribunals? And in this regard, the calls for a special tribunal on the crime of aggression, which has just been discussed in the other room against Ukraine, is primarily based on the fact that the ICC does not have jurisdiction with respect to the crime of aggression resulting from the Russian use of force in Ukraine. Likewise, and we've just been talking about the lack of, at present, in some cases, ICC jurisdiction over crimes committed in Syria, has led some to call for states to pool their universal jurisdiction to create an international tribunal to deal with the use of chemical weapons in Syria. So those are cases where the ICC does not have jurisdiction. But second, even in cases where crimes fall within the jurisdiction of the ICC, there may be good reasons for the establishment of some sort of tribunal at the international level. For example, it may be the case that it is sought to establish a regional tribunal as an institution that's able to deal with the prosecution of international crimes in cases where domestic tribunals are for some reason unable or unwilling to act, but a tribunal which is closer, physically closer, to the territory where the crimes were committed and to the victims. And as an example of this type of tribunal, we have the decision by the African Union to confer criminal jurisdiction on the African Court of Justice and Human and People's Rights through the Malabo Protocol. That protocol, of course, not yet in force, but if it were to come into force, most of the crimes within the amended jurisdiction of the African Court would also be crimes within the jurisdiction of the ICC. Now, of course, there are challenges. that may exist with regard to having multiple international tribunals dealing with international criminal justice, for example, with regard to funding. However, although it is sometimes, maybe even often, suggested that to have other international criminal tribunals would be to undermine the ICC, I do not myself subscribe to that view. At least I don't think that this is the case in principle. The most important point to recall, at least in my view, is that the ICC has not yet achieved universality. It's important to recall, and in fact we hardly need to be reminded of this, that it will not always be possible to achieve Security Council referrals for international crimes, and if there are good reasons to have an international tribunal exercise jurisdiction in cases where the ICC does have jurisdiction, then there will also sometimes be good reasons for having an international tribunal in cases where the ICC does not have jurisdiction. Now, if we are on occasion to have international tribunals in the ecosystem of accountability, then we have another question, which is how should these tribunals coexist? So to the extent that a regional tribunal or some other international tribunal is investigating or prosecuting a case, to what extent should the ICC defer to the exercise of such jurisdiction? Now, of course, we have the principle of complementarity in the statute, which is designed to regulate the relationship between the ICC and national courts. And the question that I want to turn to, so the second big question I want to look at, is whether that principle of complementarity can be used to regulate the relationship between a regional court like the African Court of Justice and Human and People's Rights and the ICC. And just as a practical matter, that question is an important one because there are 33 African states that are parties to the Rome Statute, and so if the statute of that court comes into force, it's likely that there will be some overlap. Now, perhaps the principal obstacle to applying the principle of complementarity as set out in the ICC statute to the relationship between the ICC and another international tribunal is that Article 17 of the ICC statute refers to investigations or prosecutions by a state. And that might be taken to exclude from the complementarity regime cases where it is a regional or some other international tribunal that is investigating or prosecuting. However, it may be argued that cases where a regional or international tribunal are investigating or prosecuting, that those cases fall within the Rome Statute as currently drafted, because the question is, what does it mean to say that a state is investigating or prosecuting? International tribunals, regional tribunals are created by states, and indeed, in my view, international tribunals exercise jurisdiction not only because states have conferred jurisdiction on them, but because those states have collectively delegated jurisdiction that they possess to such tribunals. These tribunals, in my view, do not have an autonomous criminal jurisdiction, but they get them from states. So when states create a regional or international tribunal to prosecute international crimes, those tribunals are exercising to some extent the collective jurisdiction of those states. So a purposive interpretation of the Rome Statute is one that may take the view that when an international or regional tribunal created by states is exercising jurisdiction, it can be considered that within the meaning of the Rome Statute, that those states, by delegating that exercise of jurisdiction, are indeed prosecuting or investigating. And so in that way, it may be possible to bring the relationship between regional tribunals and the ICC within the ambit of the complementarity regime. Well, thank you very much.
Dapo, thank you. It's much appreciated. And as one would expect from the Chichele Professor of International Law, extremely well argued and presented. Thank you very much for putting those issues squarely in front of us. I have, by the way, been asked by the interpreters if speakers could emulate the moderator and speak very slowly. It comes with age. The thoughts take a little bit longer to present themselves to the mouth. Antaguise, you have vast experience in the area of defending the criminal defense lawyer at the Paris Bar since 1999. She's more than 20 years of experience in defense teams before international courts. She's worked in several cases before the tribunal in Rwanda, been the international lawyer for former head of state Khieu Samphan before the extraordinary chambers in the courts of Cambodia, and a counsel before the Special Tribunal for Lebanon. She's also joined the defense of Mr. Alfred Yekatom before the ICC. Madame Guisset, c'est un plaisir de vous.
Madam, it is a pleasure to welcome you and to give you the floor. Thank you very much. Good afternoon. Afternoon, all excellencies. I would like to begin by very warmly thanking Madam Fernandez de Gourmendi, President of the Assembly of States Parties, for extending the invitation to the ICC Bar Association to this event. This association is perhaps better known under its English acronym, the ICCBA, and militates in favor of the Council for Defence and the staff, support staff working at the ICC, as well as the accused and victims. It's a sign of how important this association is, and I'm very pleased to be here as Counsel for the Defence. So very often we see that the voice of the defence is not always welcome when we talk about the Rome Statutes, the ICC, and international jurisdictions. We see this quite often, and I say so with a hint of humour, but an element of truth as well. We're often seen as a necessary evil, as a partner rather than as a partner for dialogue. And I hope to show today that this is not the case. Exchange of experience and reflection can bring a great deal to the table if we want to improve the ICC system, including the defence, of course. And so, in the time that has been allocated to me today, I would like to speak a little bit about the challenges the defence faces, and I would like to perhaps to begin with our role as a discordant voice on the question of the fight against impunity, because everybody seems to agree that having a strong and capable defence is the first guarantee of a fair trial. But nevertheless, sometimes because we have to deal with particularly difficult situations with mass crimes, with entire populations sometimes that are suffering, it is sometimes difficult to remember that a fair trial actually, the key pillar of this is the presumption of innocence, whereas very often when we're talking about cases brought before the ICC, there is a presumption of guilt. And this has very concrete manifestations in our daily work, for instance, on difficulties that we may face when it comes to requests for cooperation with certain countries, as regards evidence, for instance, that we would need. Speaking on the anniversary of the Rome Statutes and speaking about this means that I have to remind you that the criminal process here is a trial of individuals rather than a situation. When we are talking about a trial at the ICC, it is one or more individuals who are being prosecuted for very specific activities in a time-bound and location-bound moment and time and place in the world, rather than a whole situation. And there does seem to be a great deal of pedagogical work that needs to be done in order to explain to people what this really means, an international criminal case. A great deal has been done. Obviously, the Rome Statutes were created in order to bring to justice grave crimes that have shocked the international community. But outside of that context, once we are talking about a specific trial, we must remember that we are judging an individual and a person. And what this means is that in the course of a criminal trial, there are three possibilities. The person may be convicted, there may be a partial conviction, and the person may be acquitted. There may be an acquittal. And this, I hope, my contribution to the event today. I've heard a lot in the commentary and in the remarks when there is an acquittal that sometimes this is referred to as a failure. And this is a real question. Do we agree on what a criminal trial actually is? It means that we are contrasting items of evidence. There are parties for and against, and a judge will apply the law. And one of the possibilities of this is an acquittal, one of the possible outcomes. And one of the things that I feel that I don't hear quite enough is this point, and this is why I'm talking about it today. Talking about a failure or a failing when you're expecting a decision or a ruling also means that you don't really realize the importance of the trial and the legal process. Once again, this is comparing and contrasting, a confrontation of different points of view, opposing truths and evidence. And it is law that must always prevail. It is the law of the victims, the rights of the victims, the law that governs a fair trial, and the rights of the accused as well. I wanted really to highlight today that when we talk about the work in raising awareness about the ICC, this means also trying to ensure that people don't have any illusions about what can be achieved by the court in certain situations. Sometimes rulings are unexpected, but the debate that takes place is also part of what people can use later on. When we talk about situations in crises, when we look into it, we go into some of the underlying reasons, and this also gives us some lessons to be drawn. Talking about the comparing and contrasting also leads me to talk about the means that we have for this. I have been working in this area for a number of years now, as I am a dual national. I am Senegalese and French, and the fact that I'm here today is also because I had no trouble traveling. I was able to undertake a certain type of training. I was able to get a Schengen visa to do a stage at the ICC, and it's very difficult to do that when you come from certain countries. And for this also, I also want to highlight the need to have a renewal of the pool of lawyers and specialists, legal experts, if we want these complex crimes to be trialed. We must have a renewal of this entire generation of jurists, and this is an important point, and I hope very much that in the next 25 years there will be work done to enhance that. And also there's the question of reform of legal assistance at the ICC. We must be very careful here as well, because there are a number of professionals who are discouraged by the working conditions that the defence face, and that you cannot have a fair trial without a strong defence. And the fact that there is a brain drain going on because the conditions are not the same, I think this is a real shame. I think it's a shame also for the development of the court. And so then the question of means and training is linked to complementarity, which is my last point. If in the future we have judges in Congo, Burkina Faso, or wherever it may be in Asia, if we really want them to judge these cases with respect for the rule of law, with access to justice for all, including victims, we must understand that this type of case is becoming more and more complicated every day. I have seen over the course of my career, over 20 years, we have photo satellite images. It's just become so incredibly complex and technical. We really do need experts in order to understand these cases. All of this experience is going to have to be transmitted to the next generation. We would need to use this in order to train future generations who will have to sit in these courts. And the question of the budget is a real issue. This is a question that I'm sure is going to come up in the future. I have participated in a lot of training of jurists in Central Africa and elsewhere, where people struggle to access their emails. How can we have access to jurisprudence? How can we access legal research online? This is an issue, and this is my vision as a practitioner, and these are some of the issues that I wanted to highlight and share with you. So, yes, there are many challenges that we are facing if we want to move towards excellence, towards the professionalization of all of these jurists who want to be a part of the international criminal ecosystem. And the Council for the Defence are certainly stakeholders. We want to participate in this discussion, in action, in terms of raising awareness and also training. Thank you.
Merci beaucoup, Madame.
Thank you very much, Madam. You have given us some really quite significant concepts about the presumptions that we have about our systems of justice. And I think it's very important for everyone to recognize the facts that you've mentioned, the individuals as well. These are not crimes or circumstances, but individuals who are being judged, and there should always be a presumption of innocence, of course. I think this is an important precept, and thank you for reminding us.
Panelist, Katarina Trendafilova, who's the former judge of the International Criminal Court. It's a great pleasure to welcome Judge Trendafilova with us. She was on the court from March 2006 to March 2015. She advised the Ministry of Justice on the establishment of the ICC. She also headed the working group on the reform of the Bulgarian Criminal Procedure Code in line with European international standards. But 1988-99 was representative for her country at the UN Commission for Crime Prevention and Criminal Justice, and also served as a deputy district attorney at the Sofia District Court, as well as a barrister with the Sofia Bar. So, Judge Trendafilova, we're glad to have you with us. Look forward to hearing from you.
Thank you very much, President Fernandez, Vice President Rey, Excellencies, dear colleagues. In the concept note that was kindly submitted to me, it has been clarified that the particular focus of our discussion today is expected to be on the complementarity regime, the cooperative trends with national jurisdictions, and other accountability efforts. And being quite disciplined, I try to reflect on the topic, just as one of the first ICC judges who has been dealing with the concept of complementarity in some of the challenges that we have been facing in the chamber that I was presiding over. And I will take you briefly through the developments of the court jurisprudence towards a more intensive cooperative trends with national systems. As everyone knows, complementarity, as the cornerstone of the Rome Statute, is reflected in a number of provisions, and I'm not going now to refer to all of them, starting with 17, 18, 19, 20, and some others as well, but also in paragraph 10 of the Rome Statute. But equally very important are paragraph 4 and 6 of the preamble to the Rome Statute, emphasizing the responsibilities of states to effectively investigate and prosecute co-crimes falling under the jurisdiction of the ICC. And thus, it is very clear that the primary duty lies with national jurisdictions, to which ICC is complementary. In the early days of the court, there was no jurisprudence that could give guidance to states on the interpretation of complementarity or anything related to the admissibility test. This posed difficulties to states how to conduct their domestic investigations so that they satisfy the final assessment to be made by chambers. In the initial jurisprudence, the IC judges applied a very stringent interpretation of the statutory provisions relevant to complementarity. I will make reference to some of the judgments. The first judgment, the first judgment was an arrest warrant in the form of an arrest warrant in the Lubanga case that was issued by Pretrial Chamber 1. And it has given the first interpretation of Article 17, which is considered to be the heart of the complementarity assessment. There are two important issues that found their way in this arrest warrant. The first one is the test same person, same conduct, but there was no much development on this test as far as this is an ex parte proceedings, so there was no exchange with party or parties. The second important issue is the concept that was developed by Pretrial Chamber 1 of inactivity or inaction of states, which is a criterion which was introduced by this chamber and was dealt with by this chamber before the chamber resorted at all to the willingness or ability of states that is directly reflected in the wording of Article 17. This criterion had the benefit of avoiding judgments on states' intentions or judicial capacity, which from a policy point of view, policy perspective, showed respect for states' sovereignty and reduced, to an extent possible, some potential tensions between states and the court. Importantly, the appeals chamber, in its composition back then, endorsed this criterion, inaction, inactivity, in its judgment on the Katanga appeal in September 2009. The second chamber that dealt with the complementarity was when there was a first admissibility challenge lodged by a state, and this was the Kenyan government. I was a member of this chamber, and now you will hear me being critical about the approach that was taken by this chamber. The chamber also addressed two important matters. The first one, the same person, same conduct, that was followed, the test that was introduced by Pretrial Chamber 1, and the same test was followed in the judgment of this chamber. The second was something very positive because we have introduced the important criteria so that they could guide state authorities in conducting national investigations. And these were the requirements that presented the expectations of chambers to be approached with such a challenge, that states have to provide concrete and tangible evidence about their national efforts, and not simply to refer to intentions of the state. And that is what actually we have been experienced, because the Kenyan government challenged the admissibility of the cases by referring to the intentions to amend the constitution, to have new legislation, and to start an investigation. So actually, the critical comment that I want to refer to is that the Pretrial Chamber 2, didn't take a more flexible approach in its exchanges with the national authorities of Kenya. As soon as we were not satisfied with the future intentions, we didn't give a little bit more time to the government of Kenya, for example, to provide, of course, with a certain within specific time limits, to provide information about some efforts that were put into the national proceedings, and to, for example, provide some periodic reports. So we were very, very demanding, and we decided on the basis of what we had, something that actually did not endorse the positive complementarity, which in a sense is to encourage and support national efforts to carry out domestic proceedings. In this, of course, there was an appeal to the appeals chamber, and for the first time, the appeals chamber loosened up this test, same person, same conduct. In its judgment that was issued in August 2011, the appeals chamber, in the then composition of the appeals chamber, they decided to make the test more flexible by making reference to the same person and substantially the same conduct, which lowered the threshold and provide more opportunities to states to prove their case with regard to challenges to the admissibility of specific cases. And this more flexible test that was introduced by the appeals chamber has been followed and favored by other chambers in the jurisprudence to follow throughout the years. For instance, and here I will refer to the case against Mr. Gaddafi and Mr. Al-Zenoussi, stemming from the Libyan situation that we all remember that this is one of the two cases when the Security Council has seized the ICC with this, the situation in Libya. Pretrial Chamber 1 moved closer to the idea of the positive complementarity. And by the way, Pretrial Chamber 1 was presided over by President Fernandez. So the pretrial chamber engaged for a longer period of time with the national authorities. They conducted hearings, received additional submissions, new evidence regarding the admissibility challenge. In the end, having analyzed the different circumstances of Mr. Gaddafi and Mr. Zenoussi, the chamber decided differently on the admissibility challenges with regard to both of them, to either of them. With regard to Mr. Gaddafi, the admissibility challenge was denied. With regard to Mr. Zenoussi, it was granted, and thus the case was deferred back to the Libyan authorities. On appeal, the appeals chamber not only endorsed, but further on developed its approach towards the more flexible same person, substantially the same conduct test, so that the Libyan authorities in their domestic investigations could capture more incidents and substantially the same range of criminality, but not exactly the same. Now, more recently, the same tendency aimed at engaging more with the state, which was followed the decision early this year. And this is the challenge with regard to the Republic of the Philippines, posed by the Republic of the Philippines. In this case, upon the chamber engaged thoroughly with the domestic circumstances, so it gave a lot of importance to what has been going on at the national level. In the end, however, having given a thorough consideration of the national domestic proceedings, the judges still decided to grant the resumption of the prosecutor's investigation because the initiatives undertaken by the Philippines did not amount to tangible, concrete, and progressive investigative steps that sufficiently mirror the court's investigation.
We have to wrap it up a little bit because
yes.
Some chance for questions.
So, and finally, a recent example is the Venezuela situation, which has been under preliminary examination since February 2018. The prosecutor decided to start an investigation in 2021 and concluded on the very same day when he took this decision the Memorandum of Understanding with the government of Venezuela to foster mutual cooperation. Soon thereafter, Venezuela requested a deferral to the domestic system. But quite soon, the prosecutor, having monitored the situation, approached the pretrial chamber requesting that he resumes an investigation. So importantly, and in line with the concept of complementarity, the pretrial chamber highlighted, number one, Venezuela is not precluded from approaching either the OTP or the pretrial chamber in the future with material to justify inadmissibility on the basis of complementarity. And second, assessing the state of domestic proceedings is an ongoing process and requires continuous dialogue with the relevant state and the court to ensure that the principle of complementarity is upheld. Now we are expecting...
We have to wrap up. We have other speakers.
We have tomorrow to follow the judgment that will be issued by the appeals chamber of the International Criminal Court, where they're going to provide a final assessment pursuant to Article 18. Thank you very much.
Thank you. Thank you very much. Thank you so much. We have a chance for some questions. I know that my colleague, Ambassador Skoog from the EU, would like to ask a question. I'm going to give the floor to him and then see what we have any more time. Olaf.
Well, actually, thank you, but it's Silvio.
Oh, Silvio. Okay, all right.
But from far away, we look the same.
Even better, even better.
I'll be very short. And just to say that we are very happy to have contributed to holding this important event on the 25th anniversary of the adoption of the Rome Statute. And we agree to with the general title that we need to connect all the dots and strengthen the international criminal law ecosystem. Following on from the Nuremberg tribunals and their principles, the international criminal justice culminated with the adoption of the Rome Statute of the ICC 25 years ago, and this is really a milestone for the international criminal justice system. The ICC is a young institution that has delivered on its mandate to end impunity around the world, and the court has put the victims at the center of its proceedings. But what I would like to say here is that there are other international or internationalized courts and independent investigative mechanisms that have brought their fair share to the development of international criminal justice, and we should remember them today. By issuing, for example, the first indictment against the sitting head of state, the ICTY taught the world that no one is above the law. And by being the first international tribunal to enter a judgment for genocide and to recognize rape as a means of perpetrating genocide, the ICTR significantly expanded the law with regard to sexual violence crimes. By making a priority in prosecuting sexual and gender-based crimes, the Special Court of Sierra Leone made a significant contribution to gender-sensitive transitional justice. And by allowing victims to participate as civil parties and to seek collective and moral reparations, the extraordinary chambers in the courts of Cambodia innovated in victims' participation in proceedings. And lastly, by collecting invaluable evidence, the independent mechanism for Syria and Myanmar will contribute immensely to prosecutions of the most serious crime that happened in those countries. These are all significant contributions to the development of international justice, and we need to capitalize on them and strengthen the system even more. Because international criminal law and its court system is not about the number of convictions, nor about the number of trials or the number of persons behind the bars. It is not about retribution. We believe that international criminal law is about peace through law, and we hope we can work together in strengthening further to fight impunity around the world. I thank you, Bob.
Thank you, Silvio. Colleagues, I think we're in a bit of a dilemma because I know there will be many who will seek to ask some questions or comments, but we do have other panels, and I want to be respectful of their time as well. I notice that my boss is looking at me and very quietly nodding as I say these thoughts. So I think what we should do is draw this panel to a conclusion. Let me thank all the panelists. I think they provided us with some provocative thoughts and thinking about this question of the architecture, the cooperation between different courts, and the issue, the fundamental issue of complementarity and also of the rights of victims as well as the rights of accused. And so I think we've had a lot to mull on, and appreciate very much the comments that have been made by our panelists, and I think we'll give our seats over to the next panel, if I may. Thank you very much.
Good afternoon, everybody. May I kindly ask you to take your seats again? We're going to jump right at the next panel because we are short on time, and we believe that this panel is going to bring quite a lot of debate and interaction that we're looking forward to. Thank you very much. My name is Deborah Ruiz-Verduzco. I'm the new executive director at the Trust Fund for Victims. I have the honor of being joined here by the chair of the board of directors that you met already during the opening segment, and as well as by another member of the board of directors, Mr. Andres Parmas, who is also representing the Estonian delegation today. And on behalf of all the board of directors and the secretariat, we're very pleased to be moderating this panel, bringing together all the different stakeholders that participate in the process that, as Mrs. Minu Tavares Mirabal described, within the Rome Statute, from participation to reparations throughout the judicial process and also outside of the judicial process in non-judicial activities. You have the biographies of our panelists with you when you receive the documentation, so I'm not going to be repeating them. I will just signal to the capacity in which the speakers will be talking, because it is important to understand the perspective that they will be providing. We are going to take a critical turn into things. This panel will try to present and describe how the process of victims' rights gets realized in the court, which is sometimes a mystery unless you're following very closely the proceedings, and also look at certainly achievements and how the system has matured through thinking about victims' issues, because as you know, the Rome Statute contains important provisions, but there was not enough time in Rome to develop all of them. So there is a considerable aspect of judicial interpretation and judicial development through jurisprudence that has happened in the past 15 years at the ICC. And also there are important operational elements that are very specific to the cases, to the types of crimes that are being prosecuted, and to the political security context in which the participation or the reparations take place. So we hope that at the end of this panel, we come out with a better understanding of how things work, of what are the challenges, and also hopefully with a more united view of what we want to achieve and what it takes to achieve the mandate of the Rome Statute. So without further ado, I will give the floor to Your Honor, Judge Chang Ho Chung, a judge at the International Criminal Court, who is presiding on a number of cases related to reparations. He will describe, from his perspective, how the judge lives and experiences this process of interaction with the victims. I will be quite strict with the time. I don't think I need to do that with the judge, but in any case, I will be discreetly signaling when it's time to stop and go to the next panelist. Thank you, Your Excellency.
Thank you very much, Deborah, Madam Moderator. Judges always have an obligation to try and judge independently and impartially. Therefore, judges should always treat all parties, including victims, equally and fairly, and should not be biased because they are victims. However, ICC judges are also obliged to implement victim participation and reparations as provided by the Rome Statute, without prejudice to the right of the accused and fair trial. Today, I'd like to share with you judges' effort to ensure this adequate remedy to victims of the Rome Statute crimes. The Rome Statute provides, next slide, please, participation and reparation as a separate procedure. But I believe that both are linked very closely in the sense that the reparation can start and be implemented in a more efficient way if victim participation can be made as many as possible. I will explain this more later. Further, I also believe that reparation itself is an important form of reparations. Therefore, developing procedural practices to ensure transparent and efficient victims' participation is the beginning of the remedy for the Rome Statute victims. To this end, with the help of the registry, especially VPRS, Victim Participation Reparation Section, judges have developed procedural practices that can effectively decide whether to admit participation applications or not. and those procedural practices are published in the Chamber's practice manual. And as you can find from this chart, through these practices, judges have been able to make decisions on thousands of participation applications without any delay of pre-trial or trial process. In Taganda case, more than 2,000 victims, and Ongen case, more than 4,000 victims. Next slide, please. On the contrary, as you may know, reparation is the final procedure of Rome Statute system and is possible only after conviction judgment has been confirmed. This means that the victims have to wait until confirming of conviction judgment to know that reparations are available. In this regard, it is an important duty of judges to improve our procedural practices to deliver trial judgment, either conviction or acquittal, as early as possible in order to reduce victims' waiting time. To this end, since 2015, ICC judges has held a judges' retreat annually to discuss the harmonization of the procedural practices in order to make the court procedure more efficient and effective. This is the photo of the first retreat held in 2015 in Nuremberg. Furthermore, the judges also, next slide, please. Judges also agreed to make harmonized practices available to the public through the publication of the Chamber's practice manual. Now this manual is covering all the Chamber's process, including the participation, as I mentioned, and as you can find this in the ICC website. Next slide, please. As you can see from this chart, the electronic court system or judicial workflow platform of the ICC is covering all the bodies and all their work. And recently, the Chambers launched the case law database of judges' decision in English, French, and Spanish version. Now, retreat, manual, and platform are operating as court-wide tools to make the whole court procedure more efficient and effective. Next slide, please. Pretrial Chamber 2 for Ongen case adopted a new confirmation decision structure that clearly separates confirmed charges from the reasoning part in order to avoid any difficulty in verifying what are confirmed charges. Furthermore, the Chamber developed procedural practices to reach a confirmation decision efficiently, and those practices are also published in the Chamber's practice manual. As a result, as you can see from this chart, Pretrial Chamber 2 was able to issue the confirmation decision within 60 days after the hearing was completed. This blue part, which is much shorter than previous cases. And the preparation period of the following trial, this red part, was also greatly shortened because the litigations to verify confirmed charges were all eliminated. Next slide, please. The most important evidence principle in the Rome Statute is that testimony of a witness at trial shall be given in person. And the first couple of cases followed this principle. And as you can find from this chart, it used to take an average of more than 5 hearing days for one witness to be heard. Trial Chamber 6 for Untanganda case applied Rule 68, which is an exception to the above principle, to more than 30% of witnesses. The Chamber also allowed witnesses to testify via video link in the field office instead of traveling to The Hague. As a result, average hearing days per witness reduced to less than 3 days. Currently, all trial chambers are applying Rule 68 and video link testimony. Next slide, please. In addition to these procedural improvements to reduce victims' waiting time, judges also have developed important jurisprudence concerning the victims. Pretrial Chamber 2 ruled that forced marriage is a form of other inhumane act of crime against humanity. Trial Chamber 6 ruled that members of the same armed force are also potential victims of rape and sexual slavery as war crimes. Trial Chamber 6 also ruled that children born out of rape and sexual slavery victims may qualify as direct victims. Now I believe the one remaining, next slide please, challenge that judges have to overcome is the reparations, more specifically, reparations order. As I mentioned, through participation procedure, all conviction cases have already hundreds of or thousands of victims who have been identified and admitted. And if the conviction judgment is confirmed, the convicted person already has an obligation to repair all the harm of the victims. Therefore, there isn't any problem in issuing the reparations order for those admitted victims. However, as you can find from this chart, it used to take many years for the reparations order to be issued and to be confirmed, and eventually delayed seriously the start of implementation of reparations. Lubanga case, conviction confirmed in 2014, but reparations order was confirmed in 2019, almost 5 years. Katanga case, almost 4 years. Ntaganda case, already more than 2 years have passed, but we do not have any confirmed reparation order yet. Ongen case, we do not have any reparation order yet. This delay is mainly because the court jurisprudence requires reparations order to cover not only admitted victims, but also potential victims who have not yet applied for reparations. This means that reparations order should estimate the number of potential victims and also estimate their harm and the cost to repair. Unfortunately, method and criteria for estimation of potential victims have not yet been developed by court jurisprudence. Further, even though there are many methods of estimating potential victims, estimation results are varying greatly depending on which method is used. As a result, again, estimation of potential victims in every reparations cases have taken so long, have been appealed, and sometimes been remanded by appeals chamber. Last Friday, 14 July, the trial chamber 2 for Untanganda case in the chart delivered a new reparations order. You can find it in the ICC website. This new order is estimating potential victims mainly based on actual cost spent for previous implementation by Trust Fund for Victims. If this new method and criteria is confirmed by appeals chamber, this new reparations order will serve as a jurisprudence for this estimation of potential victims. I look forward to your continuous interest and comment on this issue. Thank you very much.
Thank you, Judge. Indeed, the process is complex and the jurisprudence is evolving, and there is certainly a framework to which the court, the judges, the chambers, and the participants and the parties are referring to in trying to advance the conceptions, but also the methodologies for going from the rights to operationalizing those programs. And in this respect, we would hear a little bit more about that framework from a very important guest. This connects the ICC to the UN system of human rights. We have with us the Special Rapporteur for Truth, Justice, Reparations, and Guarantees for Non-Repetition, Fabienne Savioli. I give you the floor now. Thank you.
Muchísimas gracias, señora directora.
Thank you very much. Executive Director for the Secretariat of the Trust Fund for Victims, Ms. Ruiz Verduzco, Judge from the International Criminal Court, Vice President of the Court, and Secretary of the Court, Ms. Silvia Fernandez. Dear friends, 25 years ago, I joined the official delegation of the International Secretariat of Amnesty International at the Rome Conference. I attended the adoption of the statute on the 17th of June 1998, that historic day, and it was a great moment. It's a real honour for me today to attend this anniversary here at this such prestigious panel with all of the great members of the panel, and I wish to thank you so much for inviting me. Thank you to the President of the States Parties, Ambassador Silvia Fernandez, for inviting me. The work of the International Criminal Court is very closely linked to my mandate, which is identifying all post-conflict aspects and issues coming out of dictatorships or authoritarian governments where serious human rights violations or violations of international law were committed, to strengthen and build peace and to establish democratic societies. As the mandate holder, I have emphasised the fact that states in transition must assume their obligations under international human rights law and must steward their political will to establish pillars for transitional justice: truth, justice, reparations, guarantees of non-repetition, and memory. Those are the key pillars. The international community must use all of the tools and procedures available to it to achieve these objectives. My report on the trying and punishment of persons responsible for serious human rights violations and serious violations of international humanitarian law, presented by the Human Rights Council in 2021, identifies accountability standards and takes account of the very important work that the International Criminal Court has been engaged in since it was created. Now, what does adequate redress imply for the victims of such atrocious crimes that are under the jurisdiction of the court? Well, international law guarantees victims the right to effective remedy and swift, adequate and also effective and comprehensive reparations. Since these are the most serious crimes, that is, crimes that offend the international community as a whole, reparations cannot be restricted to redistributive justice, but rather, additionally, we require a raft of different aspects that make up comprehensive reparation, redress, rehabilitation, satisfaction and guarantees of non-repetition alongside economic reparations. And states have the duty to make the rights of victims to reparation effective. Individuals, corporations and non-state armed groups who are involved in the commission of these crimes also have a responsibility to contribute to these reparations. Other entities that can also play a very important role in reparations are international organisations, donor countries, and philanthropic entities. Reparations from all of these entities is crucial to effectively realise the rights of victims. In order to guide the different relevant stakeholders, many studies have been engaged in on this. I've examined the practices of states in national reparations proceedings in my report to the Council in 2019. Public apologies also as means of satisfaction in my report to the General Assembly in 2019. I've underscored the need to engage in transformational measures and reports on gender and transitional justice that was presented to the General Assembly in 2020. As regards my reports on the legacies of colonialism presented to the General Assembly in 2021 and on the role and responsibility of non-state actors in 2022, both of these reports have specific chapters on the role of former colonial states and the role of non-state actors in providing reparations and also financing them. Further, my upcoming reports on legal standards in transitional justice processes obviously includes standards under the reparations pillar. And my final report to the Assembly that I will present here in New York in October this year refers specifically to the financing of reparations, where we underscore, among other things, the very important role that the trust fund plays in this regard, as well as some of the restrictions of a budgetary nature that require an urgent commitment from the international community. All of these documents provide clear guidelines to the states affected and to the members of the international community, including international organizations and donor countries, when it comes to the design, implementation, and financing of reparations for victims. Although I don't have the time here to give detail on this, I would invite you to peruse these reports. In my previous role as a member of the United Nations Human Rights Committee that I served on for 8 years, and currently in the 5 roles that I play as mandate holder, I was struck and concerned by the lack of compliance when it comes to reparations for victims. In many cases, the situation that family members and societies find themselves in is worse than the situation before the violations were committed. This re-victimizes the victims and is a reality that should compel all of us, that should compel the whole of the international community. I wish to underscore that victims cannot be left in a place where they are not satisfied in terms of their right to truth, reparation, and justice. Further, restorative justice mechanisms can be applied in a complementary manner. However, they cannot replace the most important principle, which is accountability before the criminal justice system. The most serious crimes must be subject to the harshest sentences, sentences that are tantamount to the crimes committed, because impunity in law is not acceptable. However, impunity, de facto impunity, is not acceptable either. Furthermore, while all harm should be subject to reparation, it is logical to underscore that the more harm caused, the higher the reparation should be. The Trust Fund for Victims plays an extremely valuable and noteworthy role when it comes to reparations, in particular when it comes to psychosocial rehabilitation measures. Processes of transitional justice in general are not tied to the outcome of criminal cases. They have a broader mandate than the framework provided for under the Rome Statute. For this reason, in a complementary way, the use of the trust fund is absolutely essential. Different national and international stakeholders that intervene in mechanisms of transitional justice give priority to reparations and must demand states to comply with their obligations in this regard and cooperate in this direction. No process of transitional justice can be considered to have been effective, legally valid, or morally acceptable if peace is sought by providing impunity to the perpetrators and if reparations are absent, and of course if further pain is caused to the victims and members of their families. It is our obligation, our duty, to do everything we can to ensure that the rights of victims and the rights of their family members are effectively provided for. And this would be the best tribute that we could pay to those who fought over decades against the greatest atrocities, and who, over the last 25 years, have bound us to this instrument with a view to fighting against impunity, providing justice, and recovering the dignity of victims. Thank you very much.
Muchas gracias, Professor Savioli.
Thank you very much, Professor Salvioli. Thank you for that appeal and so well linking together all of those different concepts that are required to fully implement reparation programs, particularly. Your presentation alluded to, and this is very important, one of the objectives of our strategic plan in the Victims Fund, that is sharing knowledge. and building on what has already been done to improve our evaluation and establish a framework of indicators to measure whether we're doing things well and look at what we need to improve. So thank you for collaborating with us on these things.
Highlighted important challenges and gaps and the direction in which ideally the trust fund and states at the domestic level should gear towards realizing the rights of victims. We will hear now also a critical perspective from the experience of those who represent victims before the proceedings, from participation throughout the judicial process and until the reparation phase and the implementation of reparations. For this purpose, we have here one of the most important and vocal legal representatives in the cases, particular of Lubanga. As you may know, the case against Mr. Lubanga concerns charges for the conscription use and recruitment of children in armed conflict, and therefore concerns the provision of reparations to more than 2,000 victims, now adults, whose childhood was stolen. And we would like to hear from you, Mrs. Umbeli, to hear of your experience, and I believe that your presentation will also illustrate the other side of what Judge Chung has also described from his perspective. Thank you.
Merci beaucoup, Madame.
Thank you very much, Madam Denborough. I would like at this point to point out a few remedies with a view to making progress with reparations for victims under the Rome Statute. We have spoken today about the issue of placing victims at the heart of the mandate of the ICC. I would like to draw everybody's attention to the fact that it's extremely important that we highlight that the initial choice to prosecute and the choice of charges brought is actually fundamental for victims under the Rome Statute. And I think, personally, as a lawyer who has accompanied victims, it's essential that we improve the mechanisms for interaction between the Office of the Prosecutor and the victims before inquiries and during investigations. Why do I say that? Well, there are, of course, reasons underpinning this. The first is that victims are the best place to provide the Office of the Prosecutor with information that will allow them to establish the existence, nature, and extent of the crimes that they have been victim to, but also any prejudice they may have suffered. Also, victims can share their knowledge with the Office of the Prosecutor in terms of the context of the case, as well as other relevant information that they may not know in light of the place and the socio-cultural context in which these crimes have taken place. Also, this consultation and interaction mechanism on a regular basis allows the Office of the Prosecutor to have an overview, especially of the geographic and temporal areas, well as how the crimes themselves may actually represent the reality of crimes committed during the conflict. I would like to illustrate this with a concrete example. This is something that we encountered specifically in the Lubanga case, where indeed the victims had asked the prosecutor to include the charges of sexual crimes, and this did not go forward, whereas there were consultations, and had there been such consultations, we would not be in this situation today. As you know, this is a reparations proceeding in the Lubanga case where the victims of sex crimes have not actually been covered, and this will be covered in the Ntanga case, where in there the prosecutor finally was able to include these crimes of sexual violence. And I'm talking here about victims who were in the same military training camps as other victims, but there are some who are parties to the Lubanga case and some who are in the Takanda case. But for those who are parties in the Lubanga case, the fund for the victim is not able to cover these sex crimes that they would have been victim to. However, for the other case in question, the Takanda case, these prejudices, these damages have been taken into account because these crimes were part of the charges brought and accepted as such. Today, also, the problem is about bringing justice closer to the people. That we talk a lot about victims, but very often these trials take place in The Hague, whereas the victims are thousands of miles away in Sudan, in Central Africa, or in the DRC. It's important that today we think about the modalities and the possibilities for bringing this justice closer to the victims. If we really want to legitimize the proceedings that we undertake on behalf of the victims, we must be able to demonstrate that their participation is actually effective rather than merely symbolic. And I would have liked to see myself, what I understand by effective participation is indeed the possibility to regularly consult and for victims to be informed of the procedure, as well as suitable support, as well as management of the expectations of the victims. The legal representatives of the victims must work hand in hand with the Office of the Prosecutors in order to set up communication strategies vis-à-vis victims, vis-à-vis victims' communities, but also in order to identify notable individuals or leaders in the community of victims so that awareness can be raised amongst them about exactly the work of the ICC. Often there is a lack of trust. We sometimes come up against distrust amongst victims' communities, sometimes because there is a lack of information, and sometimes because information is not accurate about the activities of the court. The third challenge that we face is allowing victims to emerge from these proceedings with something that is truly meaningful, independently of the outcome of the case itself. I have accompanied victims where there were convictions, partial convictions, and acquittals. But I want to reassure you that even in cases where there were acquittals, once victims have been properly supported, properly informed, and listened to, they can testify and say that even though whether there was an acquittal, whether there was a conviction, their victimhood has been recognized, and our efforts in our quest for truth was not in vain. It's also another issue that has been raised, and I appreciated very much what the judge has said. I joined the Lubanga case in 2010. This was ruled in 2006, and it is now in 2023 that we are 2021 rather, we're beginning with the reparations. So we're talking about a very long process, and often we represent 1,000 or 2,000 people, but it's very hard for me, it's very painful. Every time I go onto the ground, I see the numbers of victims, people who have died of hunger, people who have died because of the consequences of these crimes. Every minute and every second that these trials take, these proceedings take, have irreversible consequences on the physical, psychological and material conditions in which the victims live. And this is also, therefore, a call to all stakeholders, the judges, the prosecutors, as well as other stakeholders in the registry. We would really appeal to you to ensure these proceedings are as brief as possible. We have accompanied and supported former child soldiers. At the time they were 15 years old, and now they're 30, 40 years of age, and we must now ask questions of what we have been able to do for them. The other partial, perhaps, solution that I could present today is in anticipation of discussions about reparations in general. The fund for the victims is... The victims are invited to participate in discussions of reparations at the end of proceedings, and this is not always helpful, especially when it comes to really understanding challenges that ensue from these discussions. Rather, this should be discussed earlier on in the proceedings, and I think this would really save a great deal of time. And finally, I wanted to raise the need to strengthen the principle of complementarity. At this time, it is true that the court or the office of the prosecutor does not have a mandate in order to force states to prosecute the perpetrators. But when we see what is happening in the DRC, in Sudan, in the Central African Republic, where we represent those who have been victims of sexual violence and crimes in 2001, and they are still victims 20 years later, clearly questions are raised. We must encourage and do more to ensure that states prosecute other perpetrators and to really fulfill their responsibility in this regard. Thank you. Thank you very much, Madame Montpellier. We thank you also for your cooperation with the Fund for the Victims and to help them, how we can work with victims to help them understand the process and to have access to these services. So I want to thank you in that regard as well.
The final speaker, civil society was essential to incorporate into the Rome Statute the different provisions as it has been explained throughout this conference, notably through the Victims' Rights Working Group, that later became a key component of the coalition for the ICC. And for this reason, we have invited civil society representative, in this case is Mrs. Dania Chaikel, who is the representative of FIDH at the ICC in The Hague. And she will be providing a perspective that is more looking from the eyes of the victims, less systemic, and more from a human perspective. Thank you, Dania.
Thank you very much, Deborah. Excellencies, dear colleagues, thank you so much for this opportunity to speak on such a critical issue. New York is actually a very special city for me. My parents are New Yorkers, and my dad arrived here in 1950 with his parents. They were refugees and survivors. So I just wanted to begin by reading to you what my grandfather, Simon Chaikel, told the Holocaust Documentation and Education Center as part of the biggest collection of oral history oral history from the Holocaust in the world. He said, "So they took my father. They thought that he's hiding us, so they beat him so long until they killed him, and my mother and my little sisters with all the other people from the village. They took them out to a forest. It's called the Bronica Forest. This is near Drohobych in Ukraine. They took all the people from the surrounding area in that forest, and they killed them there." So you can imagine the impact of these devastating crimes. It's very deep, it's very scarring, and the intergenerational trauma lives on with me in my DNA, which I've learned in the last few years. And today, as we commemorate the Rome Statute's 25th anniversary, I'm going to focus on why indeed a trauma-informed approach is vital to the work of the court. My comments are informed by conversations, consultations with staff at the court, and also with International Federation for Human Rights members around the world who are working with their communities and advocating for victims' rights. So what's been achieved? We've heard a lot today. The Rome Statute is 25 years old. It's introduced provisions which codify victims as active rights holders, including participation, protection, also information, independent legal representation, and of course, reparations. These are historic innovations, and from my perspective, they put victims at the forefront of ICC proceedings as proactive agents of justice. Saying that, however, and I think Mr. Prosecutor said that earlier today, we've definitely mastered the art of talking the talk, but we're stumbling at the moment on walking the walk. I'm going to touch upon three areas. First, as said just now by Evelyn, the distance between victims and the court is just too wide. According to FIDH members and also practitioners working every day on these issues, one of the biggest challenges that really hinders the effective implementation of victims' Rome Statute rights is insufficient outreach and two-way engagement, meaningful engagement with the court. It's reported across all situations by all members that we work with. And we're talking about interactions with different organs, so the registry and the Office of the Prosecutor. And this has directly impacted their connection to the court and their right to information, among others. And we've also seen in recent years a shift to remote engagement. And this, of course, came about because of COVID, where we had no choice. But this has stayed, unfortunately, and it presents numerous challenges and uncertainties related to confidentiality and security issues. And really, I think what I'm talking about today, it can also hinder the ability to build real connections and trusting relationships. Another way that we're stumbling is the underfunding and staffing in the registry. This really hinders key elements of trauma-informed justice. There's been a severe reduction in resources and staff in the victims' participation and reparation section, as one example, both at headquarters but also in ICC situations. And I think it's remarkable that right now there are less staff in these offices than 10 years ago, despite the increase in situations and cases. The recent surge in voluntary funds to the Office of the Prosecutor, well, on the face, this is very positive. It's created a new imbalance in resources among organs. So this could negatively affect the registry's ability to give the victims, the growing number of victims, because there are new situations, the assistance that they need and support. The final way I'm going to touch upon that I think we're stumbling is secondary trauma. Recent reports and staff surveys at the ICC report a deeply troubling workplace culture. And after talking to staff members, a concerning number are even suffering from PTSD due to exposure to the difficult cases and evidence. And this includes investigators, interpreters, and those working with victims. And it's also important to remember that there's staff at the court who come from situations who may themselves have also experienced direct trauma in conflicts there. Regrettably, there's currently very low support internally for those staff members. So what needs to change? I chose the trauma-informed approach because it is an approach that really prioritizes restorative interaction with victims. And I'm going to touch upon three ways that the court could implement this. First, mandatory training on trauma and its impact on ICC professionals. For all professionals at the court, not on them, but also on them, how trauma impacts them, including judges. And right now there is no mandatory training for judges at the court, I believe, on any issue. Sensitizing all ICC professionals through protocols and guidelines enables them to recognize the signs of trauma, respond empathetically, and adjust their strategies accordingly. This will foster a workplace culture that prioritizes well-being and stress management. The second thing that should happen, or that would be a benefit, would be to evaluate trauma's prevalence and impact in the court proceedings. We know that trauma can really destabilize people and disrupt their emotions, memory, decision-making, and it impacts everyone very differently. And it can lead to very serious psychological conditions. So if court professionals understand trauma's influence on their testimony and behavior, in addition to cultural context and gender norms, this will inform fairer and more effective legal responses. Finally, 3, empowering and involving victims more by, for instance, providing access to information through adequately funded outreach and respecting the right to independent legal counsel from the very beginning of preliminary examinations right through to reparations. All of these issues, of course, depend on a court-wide trauma-responsive strategy to really empower victims to be able to empower their Rome Statute rights. And I also wanted to mention that this, prioritizing trauma is actually a prerequisite to a victim-centered, a gender-responsive policy, and also a central tenet to the do no harm principle. And I'll just end with some of the ways these measures would benefit the court. One, this would, of course, support meaningful implementation of victims' rights in a way that facilitates their sustainable participation, and they will feel far more connected to the proceedings, enhancing victims' well-being and safety, and contributing to their healing and recovery. The legal proceedings themselves will be enhanced. The accuracy and credibility of survivor testimonies is improved, strengthening the evidentiary basis for cases. And of course, a court will function more effectively when the well-being of the staff and those working there is prioritized. And that includes minimizing the impact of disturbing material. And the last way I think it will have a big impact is that it will increase the institution's credibility, legitimacy. By prioritizing a trauma-informed approach, it shows the ICC's commitment to fairness, empathy, and victims' rights in a very tangible way. It fosters trust and confidence in the institution, both from affected communities, but also the international community at large, strengthening the court's reputation as a legitimate and effective forum for seeking justice. So to finish, coming back to my grandfather's interview, I raised it today because this oral history project was the most reparative and healing thing that happened in our story, because that was the first time my grandfather ever shared these details. It's a 2-hour interview. So I only learned of what happened to my family that way, and my dad, including my dad. So he felt finally safe enough and respected enough to speak his truth. The interviewer was very trauma-informed and respectful, and my grandfather felt comfortable. So this kind of agency really gives victims a sense of dignity and really is one of the central tenets of a trauma-informed approach. Thank you.
Thank you so much, Dania. With this excellent, very touching, but also very actionable recommendation. And certainly we are not only needing to be accompanied with political will and determination, but also with very practical measures and with more collaboration between organs. I believe some of these recommendations that both you and Evelyn are really actionable for the Trust Fund for Victims, and also for the way in which the Trust Fund is going to cooperate under the new approach in the registry and after the review mechanism with other organs in the registry, that we together form this pillar to realize the rights of victims throughout the judicial process. So we really are very thankful that this conversation is very frank, is very open, is very detailed, because we want delegates that you understand the implications, and we want your political support, we want your solutions, your understanding, as we are continuing and striving to improve in the way we approach this critical element. So I still have 5 minutes to give the floor to the delegates, and I would like to recognize First and foremost, the delegate from Canada, Honorable Robert Oliphant. He's the Parliamentary Secretary to the Minister of Foreign Affairs. Honorable Oliphant, please, you have the floor.
Thanks to all the panelists for your contributions on how we can provide adequate remedy for victims. I think all your insights were helpful. I'd like to shift the lens and just add the issue of a gender perspective to each of what you might have said for our collective thinking. I think when we're confronted with the atrocities around the globe, we recognize the mandate of the court is as profound and as important as ever. And Canada will continue to support and commend the court for its fight for impunity for the most serious international crimes, particularly, we'd like to add, for women and girls. Victims of sexual violence, victims of gender-based violence, victims of sexual violence in conflict and war. I think it behooves all of us to look at the role of the Trust Fund for Victims as an essential pillar of the Rome Statute system, helping victims and survivors of atrocity crimes to live with dignity, hope, and choice. But the systemic prejudice and discrimination faced by women and girls adds an added difficulty in the pursuit of justice at every level, both from the determination of them as victims, their ability to speak out as victims, and their ability to ask for help and reach help institutionally, personally, and really profoundly ongoing after these incidents. Canada has been proud to continue to support the work of the Trust Fund for Victims for survivors in Mali, for instance, through its multi-year voluntary funding of $4 million. This initiative, known as Réparer les Vivants, or la Résilience, or Revivre, which seeks to address harm suffered by victims and survivors, including women and girls. And Canada aims to find a durable peace by ensuring women and girls recover and receive remedy. Over the last years, the ICC has proven to be a last bastion against impunity while being a last resort tool for victims where there is no hope for justice at the national level. So my question for us to think about, it probably will have to be for us to ponder as we leave this place, is that with all aspects of society, women and girls continue to be targets of violence in conflict and war, including victims of sexual violence. And I would like all of you to have your views made more concrete with respect to how the Trust Fund for Victims and all of our organs can improve remedies for victims of such violence, and I would say again, women and girls. Thank you very much.
Thank you very much, Honorable Oliphant, and also for the support that Canada provides to the Trust Fund for Victims. Thanks to Canada's donation, all the funds that have been required to award, to meet the award of reparations in the case of Almadi for the reconstruction of the site of Timbuktu, as well as to help the community and to compensate the survivors of those killed in the attacks have been met. So we're really thankful. I have now, je donne la parole.
I now give the floor to Senegal, to Mr. Ndiaye, the Standing Secretariat of the Ministry of Justice. Sir, you have the floor. Thank you very much, Madam. Thank you for giving me the floor. Madam, 25 years ago, we reaffirmed our resolve to confront mass atrocities and to fight against impunity for the perpetrators of these crimes. We have covered a lot of ground since then, with 17 investigations, 30 cases, 2,500 hearings, 10,900 victims heard. So this is an opportunity to applaud the work undertaken by the staff of the court to successfully deliver its mission. Senegal was the first country to ratify the Rome Statute, and we attach a huge amount of importance to reparations. In this regard, Senegal wishes to encourage the court to develop its victim-based approach to ensure that victims benefit from financial and psychosocial support that they so need. We are delighted for the 2,500 victims who have benefited from reparations from the court, and to the 130,000 survivors supported by the fund benefiting victims. We are resolved to strengthen cooperation between the states, parties and the court with support for investigations, and this includes the allocation of sufficient human and financial resources for the successful delivery of the activities of the court. Thank you very much, Madam Chair, for giving me the floor. Thank you, sir. Indeed, Senegal was the first state to ratify the Rome Statute. You have also made very meaningful symbolic contributions to the Victims' Trust Fund. And we thank you very much for all of the efforts that you have made to strengthen the procedures, especially when it comes to the specific case where your leadership was very important. I will now give the floor to Estonia, please.
Thank you. Thank you for the very interesting interventions. I would like to draw your attention to one more aspect that has not been mentioned here today, and namely that the victims, you can divide them under different categories. One of the divisions that can be made is that we have situation victims and we have victims of the criminal cases. And the number of victims in criminal cases is inevitably smaller than the number of the situation victims altogether. The ICC, as the criminal court, of course, has to be confined to the case victims. But the ICC system, as such, cannot neglect the situation victims in a broader sense. In that respect, the Trust Fund for Victims has two mandates. We are complementing the reparation orders of the court, but the Trust Fund also gives out reparations to situation victims who otherwise would not, let's say, get anything for the sufferings. And I call for everyone to support the Trust Fund's work in these reparations, because when we leave some of and the big number of the victims on the roadside and only concentrate on a smaller number of them, then the ICC is definitely not putting victims at the heart of its business. Thank you.
Thank you, Mr. Parmas. We have the last speaker on the floor. I give the microphone to Romania. Thank you.
Thank you very much, Madam Moderator, and special thanks to speakers for this insightful reflection on victims' participation and reparations within the Rome Statute system. The discussion has served as a reminder that our common and consistent efforts to support the court and its activities are, in fact, dedicated to achieving the purpose of bringing justice to the victims of the most atrocious crimes. This reflection must serve as an internal catalyst for state parties. The event today has also highlighted the ICC's role as an essential instrument in the fight against impunity and in providing assistance and reparations to victims of mass atrocities as means of contributing to reconciliation and peace building. And building on that, I would like to take the opportunity to ask the members of the panel if they think it is wise to promote the court as a component of the wider reconciliation and justice framework in the aftermath of mass violence, or if it seems an excessive burden to carry for a criminal court, which is concerned with individual accountability, not with the structural causes of the conflict. And, in our view, the answer to this question might be at the core of the victims' expectations from the ICC as well. And I thank you very much in advance.
Thank you very much. We have 2 questions from the floor, but unfortunately no time to answer them. However, we will hope to have that dialogue during the reception at the end of the event, where we can exchange and interact, and we are also from the Trust Fund gathering these questions so that we can have the adequate consultations. I'm going to be overridden by judicial order, and I will give the floor to Judge Chung for the last word. Thank you.
It's not enforced, but regarding women and children issue, thank you for raising this issue. So we already, in our reparations order, we developed many principles regarding implementation of reparations, especially for victim of women and children. So as I also mentioned in our jurisprudence, we also making many important rules, jurisprudence regarding in children and women. And currently we are also looking at the possibility of making the transgenerational harm as also part of our harm in the Rome Statute system. So we are now keep developing some principles, jurisprudence, and some of these new concepts regarding women and children. So, but currently we are more focusing on judicial process as part of a court. So assistant mandate is important. That is done by trust fund as long as budget budget allows. But we, as a court, we are now currently more focusing on our role as a judicial body. So we are more focusing on reparations order. And as I mentioned, we are still somewhere, some room to settle. So we are now more focusing on this role as a judicial body rather than expanding it to all potential victims. So I hope you can understand this way. Thank you very much. Thank you very much, moderator.
Thank you, Judge, and thank you to all of you for joining this interesting discussion and for the leadership of President Silvia Fernandez for incorporating and advancing the role of victims in the Rome Statute. We go now to the next panel. Thank you.
Okay, I'm going to, because we're a bit running a bit behind time, and because I know all of you will be eager to move on to the reception, we'll start this panel. We have a stellar panel, but unfortunately, Ambassador Canu is not able to be here. He had to drop out at the last moment, so we'll try to make up for his absence, even though that might be difficult. I will dispense from repeating the bios that you in fact have, and most importantly, you know all the panelists. They're well known to you. I encourage any intervention that you might have, any questions or points of discussion after we finish. The panel's title is Strengthening the Rome Statute System, the Review Mechanism, and Beyond. And the panel is intended to take stock of what has been accomplished and to identify the way forward when the process is concluded. And is, I think, relevant that this is, in fact, the discussion for our last panel. This is, I think, a major task and hopefully a major accomplishment, but it's a task that I think is more important now, and that's because the ICC's mandate is more critical now. The war against Ukraine has certainly made that a reality. So let me start, Paul, with you, if I could. As co-chair of the review mechanism, you were there throughout the entire process. You're steeped in kind of unparalleled background in this area. And I wanted to ask you to take a step back, and what do you think the lessons now of the review process has been, and what do you think the future is going to be?
You want me to answer that first, or first give my presentation?
Make comments, and then I'm going to come back to you on those questions.
Okay. I hope I answer your question a little bit in what I prepared to say. First of all, indeed, you said Michael Kanu couldn't be with us. This is very much a joint effort. I'm very sorry Michael is not here, although he's based in New York, I'm based in The Hague. But you see, living far away is not a guarantee for not being there. Living close by, well, anyhow. And of course, we are also supported by Poland, Bangladesh, and Chile. Let me take you back a couple of years, not that far away, but in a diplomatic life, 3-4 years ago, maybe a lifetime, maybe a different posting. I take you back to 2018, 2019, perhaps 2017, I don't know. But let's focus on these years. There was a lot of concerns, and I think sometimes even distrust about the court among member states and among civil society. Concern about lack of results, about the long procedures that seem to lead to nothing but acquittals, and I know we've had a discussion, acquittal is also an outcome, but anyhow, I'm just saying you as it was felt by member states. Irritation about lack of transparency, whether justified or not, concern about the distance between the court and the ASP. Against that background, we, member states, asked the independent experts to make us a report about what should be done to strengthen the court. And I'm sure at that time no one expected 384 recommendations. But I think we all agree that the experts did a good job. And in order to guide, organize, and monitor the assessment of the recommendations, we, review mechanism, were created. Now we are a couple of years further down the road. And if I look at the process, I see that almost all recommendations have been assessed, some negatively, but most positively, sometimes with a little bit of modification. And implementation of the positively assessed recommendations has in many cases been completed or is underway. That we would come this far is not a given. The review process could have easily turned in a we against them process, given the distrust that was present and partly even the origin of the process, as I've just said. There are also concerns that the discussion of the recommendations could lead to a kind of intrusion into the judicial and prosecutorial independence. I see it as one of our most important achievements that this did not happen. I would say now that the review process has really strengthened the links between the member states and the court, and strengthened the cooperation and a feeling of a common purpose between the court and the ASP, and I also hope between the court, ASP and civil society. And the key element was that the discussion, there was the decision to discuss all recommendations jointly, regardless whether they were the primary responsibility of the court or of the member states. Transparency and inclusiveness. It's often mentioned, especially here at the UN, but I think it worked well for us. As I said, most recommendations are assessed and implementation is underway. So the question is, where are we? Is the review process completed? My answer is, and I think the answer of most of you is no. This morning, some ministers made also comments to that effect. It is important that we continue to keep track of the implementation to avoid that, despite all good intentions, in the end, no real change will take place. The review process was never meant, of course, and I think I opened a door which is already very wide open, never meant to be a paper process or ticking a box process, but should lead to actual change on the ground, actual strengthening of the court. And that holds also true for strengthening the ASP. Coming back on previous decisions, even ASP resolutions to implement certain recommendations is not helpful in that regard. Furthermore, the implementation of some recommendations require continuous effort. For example, and it was mentioned already in previous discussions, the working culture recommendations, and therefore also continuous monitoring. The court and the member states cannot afford to slip back here. Do we still need the review mechanism in this phase of the process? In my view, it's time to start to think about what one would call, I think, mainstreaming of the process. Already the existing facilitations, both in New York and The Hague, played an important role in the process. And I think the time has come that monitoring of the recommendations should take place first and foremost in the regular facilitations. And I realize there are some gaps in the ASP coverage. For example, I think the most striking example is the Trust Fund for Victims. But this could be covered without, of course, giving the start for an extremely expanding of the bureaucracy, but one or two facilitations perhaps. So creating perhaps one facilitation for the trust fund could help there. In my view, the overall monitoring of the process could lie with the Bureau. Or the Bureau can organize that in any way it wants, but that would be my idea. And let me very much stress, these are my personal ideas. They have not been discussed at length with member states and other stakeholders. That's our task, one of our tasks for the coming half year. Dear colleagues, looking back, I think we made considerable progress in strengthening the court. I think, and I was there also in 2017 as Perm Rep of the Netherlands, I think the situation now and the relation between court and ASP is considerably better than when we started this exercise. I hope we can continue in this manner. I thank you very much.
Paul, may I ask you just a follow-up, because you started with this really important point about distrust, the long proceedings, and then talking about the success of really bringing back, strengthening the purpose of the court. A lot of internal debate, discussions. Do you think this is now reflected externally? Do you feel that this review mechanism and the prior to that, the experts' recommendations report, which really, I think, galvanized a lot of people outside the court to say, well, there are issues. How do you see this mechanism as having an impact on those outside the court, both in civil society, the general public? Has it improved? Do you think it will improve the perception?
I hope so. Of course, my perspective is not entirely the entire world, so I can basically speak for my part of the world, Europe, the Netherlands, and give you one example. The working culture, I mean the report, the independent expert report, those of you who don't know it, had some very negative remarks on working culture. In my country, and I know in some other countries as well, that led even to parliamentary questions. And I think that and I don't have to tell you here, and I don't have to tell the people in the court, that a court where you use terms like sexual harassment, abuse of power, that is to the outside world, not even to politicians and diplomats, but to the man and woman in the street, that's not serious. Then there's something seriously wrong. I think that the fact that we tackled that the court is very serious in approaching that, it helps. I'm not saying that it is the remedy to all remedies. No one has ratified since because of that, but you have to start somewhere. I think that we start to think, and the court especially think about how to streamline procedures. That helps. I know one of the issues I mentioned, of course, is perhaps a little bit more dynamism in the court through a tenure policy. I think that helps. Again, is it black and it becomes white? No. And it's not the review mechanism that does the job. It's in the end the court and the member states that do the job. But I'm a multilateralist by nature, so I know that progress is not measured in kilometers. It's measured rather in millimeters. So we did our millimeters, I think. And it helps. It adds a little bit. On the other hand, would you have not done that, I think the situation would have been considerably worse. So the fact that we all engaged in this review process in that respect is I think, a very good decision we took.
Thank you for that, Paul. Osvaldo, you come into a situation that has a long history. You have a long history in the court, just endless number of positions that you've had. I can't think of anybody more qualified than you coming into this position. The review mechanism is coming to an end now. How do you see this process in impacting the Registrar's Office and your job?
Well, thank you very much, Mark, and especially thank you for those kind words, and thank you to Ambassador van den IJssel for the introduction. I think the context that he painted is very important in the way we understand what happened when we collectively, because the court was also involved in this conversation of establishing the IER, the Independent Expert Review. And I think that one of the, I had the honor of participating directly in this effort at the outset, because I was already the focal point for the registry with the expert panel, so with the experts of the IER, and then with the review mechanism at the beginning. Now, what I see is there were two main, let's say, effects of the IER process. One of them is the obvious one, is that it carved a path for improvement. And I think that is, when you look at the almost 400 recommendations, you see that there's a lot of opportunities for improving the system. But another important thing that the IER process did is that it created a precedent for a constructive engagement with the independent judicial mandate of the court and the states parties and the ISP. This is, I don't think I take this for granted in any way. Some of the frustrations that have been identified, the fact that they were channeled through a constructive process, a process of experts, independent experts, that were looking at the court from that point of view, respectful of the independent mandate of the prosecutor, respectful of the independent mandate of the judiciary, in a collaborative way, is, I think, a very important precedent in multilateralism in general, in dealing with well, in this case, in dealing with a court. And And I think this was also the first time that the inner workings of both the ICC and the Rome Statute system were reviewed in such a comprehensive way. Of course, we needed to tackle some of the main challenges that we were facing at that time. And I do want to recognize the important role that the review mechanism has played after the review itself. So one thing is the review coming up with the recommendations, but then creating the process, the inclusive process, the transparent process that is going to allow for a dialogue going forward. And in that context, I want to express the gratitude to both Ambassador Van den Ijssel and Ambassador Kanu for the great support and the leadership that they have in steering the work of the review mechanism. Now, what are the next steps? And I think this is important to understand what is the effect of this on the registry. Maybe as a preamble to this, in June this year, the ICC published a set of strategic plans. The overall ICC core-wide strategic plan, as well as organ specifics for the OTP, for the registry, and for the Trust Fund for Victims for the period of 2023 to 2025. Now, of course, strategic plans come with new key performance indicators, with a renewed strategic framework, and these enhancements in a way serve to reaffirm the significance of having a court that is accountable, adaptable, and resilient, but most importantly, capable of effectively addressing ongoing challenges that it encounters. Why is this relevant? And speaking for the registry, what the review did is it created a solid basis for determining the strategic framework that I was referring to, and the priorities for the coming years. And my predecessor, Peter, did something that I consider is very valuable for us. And is that in the recently launched strategic plan for the registry, we incorporated in the registry the IR recommendations that have been positively assessed with the review mechanism. And these are incorporated through identified key activities, concrete timelines, milestones, and deliverables. What does this mean in practical terms? It means that the recommendations of the IER have been internalized in the registry. They are no longer external impositions or part of an external checklist of the ASP, but they have become integral to the systemic goals of the organization, and they have been fully integrated in the registry's not only priorities, but also work plans, and including performance appraisals of individual staff members. So the whole let's say, system of priorities and work plans has been fully integrated with the IER recommendation. And this creates ownership. And I think this word is very important, especially when we're talking about the future of this discussion, is how do we want to continue this conversation? Do we want to continue this conversation as an external checklist going forward as to A, B, C, what has been done here and there? Or do we want to continue this conversation in a more intuitive way for the court, where the court is taking true ownership of these recommendations? And I think we need to see what system, what methodology allows for that. We touch upon issues like workplace culture. Workplace culture is integral to the court's success. The mandate of the court, when we talk everything that we have discussed today, every single aspect of the work of the court that we have discussed today is performed by staff. Staff protect witnesses, staff support the work of the judges, staff investigate in the countries where we're operating, staff provide reparations to victims. So if the workplace culture is not working, then the mandate of the court is at risk. And I consider this integral to the legitimacy of the organization. It's not an externality. It's not something that we think that others want to see is an imposition on the court. Is rather something that we need to take ownership of internally. Now, allow me to give you some examples of how we have done this, how we have integrated already some of these changes. During my mandate as registrar, one of the priorities that I have identified is I have initiated efforts to improve the functioning of our external offices and our field operations. Now, what are some of the changes that I have made are already visible in the 2024 proposed budget? And they're mostly, at this stage, is the allocation of resources by functional areas instead of fragmented by country. We think that this offers more flexibility and adaptability, but also allows for a better reprioritization of resources and allows for consistency in the implementation of registry functions throughout the different situations, regardless of whether we're able or not to have a country office. We have also, as part of this exercise, created a dedicated section within the registry that is focused on judicial cooperation, including on securing arrest. And these two priorities that I just mentioned stem directly from the IR recommendations. Recommendation 80 on field offices talks about creating offices that are adapted to the reality of the judicial activity. This is what we call the life cycle of the judicial proceedings, use local staff increasingly, have more flexibility in opening and closing offices. And Recommendation 81 talks about additional coordination between field offices and headquarters. So the improvements that we have done, in a way, come directly from the IR recommendations. The work that we're doing, the path, in a way, has been created by the IR process. The same with focusing on arrest, for example. Concerning arrest, which is, as you know, ordered by the judges of the ICC, the IR recognized the responsibilities of the registry and mandated the registry, or requested that the registry improve the coordination on arrest with the OTP and create a unified approach. Now, we have 16 suspects at large currently. This is a systemic challenge for the court, and solutions need to come from all sides. And this new focus that is both by the Office of the Prosecutor and by the registry is stemming from the IR recommendations. And then, of course, another critical outcome of the IR process that we're already integrating into the registry has undoubtedly been, and this has been repeated here, the renewed impetus and accountability on gender equality and on a safe and inclusive workplace culture. Now, the court has already been taking a number of such actions. For example, we have established the ombuds. That also comes from the IR recommendations. We have established a focal point for gender equality. That also comes from the IR recommendations. And we have adopted a strategy on gender equality and workplace culture that also comes from the IR recommendations, and which implementation is underway. And this strategy serves as a blueprint to undertake tangible impact on this area, and includes concrete actions, which are, those actions are also in themselves linked to the IER. So, for example, strengthening the internal justice system within the court, looking at some of the recruitment processes and how they work at the ICC, or coming up with an exercise to identify core values within the organization. Now, another of the priorities that I have identified during my mandate is geographical representation and gender balance. Again, this is linked to the legitimacy of the institution. If we want a justice system that is representative of the international community and of its values, then the court needs to be representative in of itself. And there's a number of recommendations in this regard, and I'm planning to conduct an internal workshop later this year that will focus on analyzing the data, evaluating efforts, and explore how to enhance the processes aiming at achieving greater effectiveness and inclusivity on this process. Again, IR recommendation created a pathway for us to do that. So overall, I think what is important is that the more and more as we progress, these recommendations become so integrated into what we're doing on a daily basis within the court that the day, and that is good because it means that we have created ownership. It means that we have been able to create processes that integrated into our plans. But at the same time, they're not static. So they will keep evolving. I mean, they create a starting point for some of the discussions, but as we go along, we'll need to continue and go beyond what the texts say currently. And this is where I think it's important that we create a framework for a conversation that is not just about whether we create a checklist, but rather how this is an evolving process and how the court is using this opportunity to enhance itself. Thank you.
You had talked about, one could even look at this as kind of bifurcating some of the internal issues, improvements that you're talking about, the work culture, the diversity, gender, geographical diversity, gender equality, versus the external, the unified arrest approach. Do you see this as you move forward as a pretty equal split between the internal, external issues, or do they lean more into the internal aspects for you?
Well, for the registry, a lot of it is, of course, internal. It's about policies and processes and frameworks and structures that are in place. Even something like arrest, I would say something internal, because we need to look at our policies, our inter-organ coordination policies. We need to look at our structures. The outputs, some of them could be external. So we talk about financial investigations, we talk about arrest. These are issues that would be related to cooperation. Field offices, for example, they have an external aspect, but they are, I guess what I'm trying to say is that it's very difficult to separate the two. Yeah. And we have fully integrated them. Thanks.
And they have an impact on both,
yes.
In the sense of the external and internal. Elizabeth, let me turn to you. Paul had mentioned the inclusivity and the transparency of the process, which I think was so critical. And civil society has played a major role on this, and your organization on the Human Rights Watch has certainly been one of the key players on this as well. So did the review process for you, for civil society, did it fulfill the objectives that you had hoped it would, or are there issues that you say, no, they just didn't meet those expectations? How do you see the process, having gone through it now?
Well, thank you, and thank you to the organizers for including us in this panel. The review process has been indeed a milestone in the development of the court and the Rome Statute system, and I think it's important that we take time to reflect on why the process began, where it got us to today, and where to go in the future. To answer your question, has it met the hopes of civil society? Well, as all of my NGO colleagues here will tell you, the hopes of civil society are rarely homogenous or monolithic. But actually, I think in this case, there was a pretty unified sense among civil society organizations observing the court, those working directly with victims and affected communities, that something was wrong, that change was needed from the court. There was really a palpable sense that the court was not living up to the legitimate expectations that victims and affected communities had for it. And I think that was a sense that was shared by the court and by states parties, as we've already heard from Ambassador van den Eysel and from the registrar. Those shortcomings, of course, were driven by both internal factors, decisions made by court officials, but also external factors, limitations in cooperation, limitations in resources that were not wholly within the control of court officials. But taken together, I think, and we're talking about 2019, which doesn't sound very long ago, but somehow feels like a lifetime ago, there was this real palpable sense of a need for change. And that was, I think, really what led court principals to ask for the Assembly to commission the independent expert review as that potential pathway to change, with the common goal of strengthening the court's delivery of justice. I think that's really what the review goal boiled down to for most of us. So has it delivered on that goal? Well, I think that's a long-term goal. I think strengthening the court's delivery of justice, whether there's been success on that, is something that ultimately needs to be measured through the eyes of victims and affected communities who are looking to this court for justice. I think we have already seen, and the registrar mentioned, a number of positive changes that have come out of the process that can be attributed to the independent expert review process. We've seen momentum in ICC elections in terms of having vetting processes that will hopefully be part of having the highest quality leadership for the court. We've seen the development by the Assembly of a strategy to respond to politicized attacks on the court, a strategy that is once again needed, probably will always be needed given the mandate of this court. And I really want to thank President Fernandez for her leadership, both on pushing forward to permanent vetting processes in ICC elections and in responding to politicized attacks on the court. I think the independent expert review and the comments already on this panel prove the point that it did give critical attention to the issue of workplace culture at the International Criminal Court. And like any of our organizations, how we do things affects what we do. And so addressing workplace culture, I think, is integral to improving the performance of the court. And there's been not only attention, but also concrete changes in the appointment of the gender focal point, the ombudsperson. And we just heard in the previous panel also all of the continuous improvements that the judges have been making in terms of the efficiency of proceedings. So there have been these positive points. And I think these are all points that I think really can go back to the independent expert review. But I think, and here I'm really on the same page, I think, with the other panelists, that really more than these incremental steps, where the independent expert review and also the process that followed, it isn't indeed, it's not just the report, it is the work of the review mechanism and the facilitations that accompanied it. Where I think the process has been wildly successful is in creating this common framework for discussions between the court, states parties, and I would, of course, also say civil society about what change could look like, what change is needed. And that sounds straightforward, but I think as Ambassador Van den Eysel said, when the process came about, it was an extremely, extremely fraught time. There were disappointing decisions. There were resource fights within the Assembly of States parties. Some things haven't quite changed. You had the drumbeat of the previous U.S. administration against the court. I mean, it was a really difficult time. And although there was a unified sense of the need for change, there wasn't, I think, a unified sense of what kind of change. And I think that there was certainly a risk, and as a result, I think certainly quite a lot of courage by the principals of the court at that time to be willing to open up the system to scrutiny. Because I think this process could have been very easily misused, not to strengthen the court's delivery of justice, but to drive through agendas aimed at addressing perhaps some buyer's remorse as to what the international community had agreed to in 1998, and trying to resize and reshape the court so that it was less than what we all hope for it in terms of its global mandate and its independent mandate. And that really, that danger, that risk, I don't think has come to pass. I think what we've had now, almost 3 years since the report and discussions, is really, again, this common framework. You can agree with the recommendations, you can disagree with the recommendations, but it's taken this cacophony of demand for change and for reform, and it's put it into some place constructive, and it's put it into a place that indeed was done with quite a lot of inclusivity, with quite a lot of attention to how can civil society participate. That's very difficult, and this process coincided in the beginning with, of course, the COVID pandemic, which put limitations on in-person consultations, but nonetheless, the review mechanism has been extremely attentive to how to include civil society's views. And so we have a framework now that I think can stand up and can serve as an anchor for the ongoing conversations that will be needed to get to that longer-term goal of strengthening the court's delivery of justice.
And Elizabeth, can I just ask, because we talk about, and the Register talked about this ownership, the ownership of the process, and you've talked about how civil society was embraced, included in this process, and now we're talking about kind of a common language. Where do you see civil society now? What's the next, how does civil society stay engaged now in the next iteration of this process?
Well, I think it is important that we all understand that this process is not, in a sense, over. It's just reaching the next phase. And of course, Ambassador Van den Ijssel, we don't expect the review mechanism to continue forever. So don't get worried. But I think the idea that we need to continue to be in an ongoing reflection and engagement about how the court is doing and how states parties are doing in their responsibilities to the court, that is something that I think will be with this assembly for all time, because the work of the court is not going to get any easier anytime soon, unless there are tremendous developments in atrocity prevention, tremendous developments in putting the Rome Statute principle of complementarity into practice. Unfortunately, the ICC is going to be needed as much as we see it needed today. And so we need to all be, I think, attentive to ongoing conversation about how to continuously improve the system. We're looking forward to the discussions in the second half of this year, looking ahead to the next assembly session on what that could look like. From our perspective, we would think that it should be governed by many of the same principles that were already there over the last 3+ years that have allowed us to get to the good result that I think we've achieved. One of those is making this a process of shared reflection between civil society, between states parties, between the court, and in civil society in particular, making sure that we have colleagues from situation countries that have real lived experience of how the court is working, how national trials are working, to bring into the conversation. So making sure it stays that shared dialogue, and yet it has to respect the principles of prosecutorial and judicial independence. And so practically speaking, I think that looks like continued encouragement from the Assembly to the court to implement positively assessed recommendations and to have some process of reporting or accountability. I think it needs to continue, obviously, to include civil society and to do all of the things that have been part of making it inclusive, everything from providing for interpretation to the scheduling of the meetings to doing meetings online. And then lastly, we would hope that now the Assembly of States Parties would take this opportunity to pivot and start to look more at the responsibilities of states parties themselves for the system. So we've had quite a lot of discussion of the court's performance, but of course, and today's event is very much on this point, that the court cannot succeed without more consistent, more sustained political support from its states parties. So we would see pivoting to look at what are the resources necessary to support the full vision of the court, which is one of the recommendations of the independent expert review. What is the role for the Assembly of States Parties to support positive complementarity? Another recommendation. What is the role of the Assembly of States Parties on arrests? So we'd like to see that pivot toward really self-examination within the Assembly and among states parties.
Both political support and financial support in order to succeed. That's great. Okay, I know we're kind of running out of time, so I want to open this up for any interventions. I have El Salvador. El Salvador is where on this?
Right here, Mr. President.
Oh, here we go. Oh, I apologize. I didn't see you there. Please.
Mr. Moderator.
You have the floor.
Thank you, Mr. Moderator. My comments will be very brief and in Spanish.
My delegation is grateful to the panelists for their words this afternoon. we recognize the relevant role of the ICC in its work globally to combat impunity. As the only permanent court with a strong foundation in the principles of impartiality and complementarity, from the perspective of my country, in order to guarantee full achievement of its work, it is essential that we direct and promote efforts of continuous improvement, efficiency, and efficacy. And El Salvador therefore welcomes the mandate of the review mechanism as the main instrument for evaluating recommendations, as well as overseeing the adoption of new measures and their application, which together should guarantee the institutional strengthening of the court in this regard. The challenge of implementation continues. Furthermore, the principle of complementarity of the court in all of its dimensions must be guaranteed. We hail the modification of Recommendation 376 carried out in 2022 in relation to the procedures for appointment and election of judges, which determines the best path towards deciding on the drafting of a non-binding document for the attention of states parties when it comes to forming or modifying rules governing their national proceedings. And this, of course, does not impinge upon the national legislation of states parties. And by way of conclusion, Moderator, Excellencies, distinguished colleagues, as regards the future of the mechanism and future steps, my delegation encourages you to continue examining the recommendations of experts in a structured, comprehensive, and results-oriented way that will strengthen not only the functioning, efficacy, and efficiency of the court, but also strengthen its impact and reach, as well as its dissemination to society more broadly. Thank you.
I want to thank the representative from El Salvador for those remarks, particularly on this principle of complementarity, which is from the very start such a fundamental principle of the court's operation. So thank you for that intervention on this. Okay, let me just then wrap this up before I turn it back to the President. First, I want to thank the panelists for being here and stepping in on this. Really superb remarks. I think we could have continued this discussion for a while. We've talked here and we've talked this morning, I recall, concerning the state party's kind of critical role in achieving the goal that we're talking about, the future of the Rome Statute system, and strengthening the performance and not only the court, but ensuring the effectiveness of the Rome Statute process as we move forward. And I think this motivation for engagement, as I sense today, still exists. It has to exist. This is essential. But the future of the court also goes beyond state party support. As stated this morning, as I was listening, the court, as it was said, represents a common objective for humanity, and as stated, a common vision, justice and accountability. And this is a responsibility of all states. This is the responsibility of the international community at large. And I'm hoping that in the next 25 years, the achievements of this court will continue to grow, and the importance of this court will be seen worldwide, not only with the support of the state parties, but those to truly make this universal. So, Madam President, I'm going to turn it over to you. Thank you.
Thank you very much, Mark, for the moderation of this panel, and thank you for all the panelists in this extremely important and interesting panel on one of the top priorities of the Assembly of State Parties, which is the review. But I would like to thank, this is the moment to thank all those who have contributed to the reflection throughout the day, at the opening ceremony and then at the round table and all the panels that followed. In case you have not noticed, the entire program was based on a recommendation of the independent expert review, which they recommended to look at and reflect on the strategic vision for the next decade, how to ensure consistent and sustainable support for the ICC. So we invited all of you to help us implement this recommendation of the experts. And of course, I'm not going to be summarizing what it was said during a very rich discussion over the day, but very briefly, I would like to highlight certain points that will contribute for this strategic vision for the next decade. I think the vision that it has been expressed today is really not very different of what we expressed 25 years ago. And here I'm going to borrow, I'm not going to pay any copyright, I'm just borrow something that was said by Mr. Lloyd Axworthy, because this was also repeated by many others after that. He said that we need a court. 25 years ago, we wanted a court worth having. And this was said by many today. Except that today, 25 years down the road, maybe we know a little bit more what that means, taking stock of the experience. What is a court worth having? First of all, we want a court that delivers high-quality justice. And exactly that's why we engage in the review. The review mechanism was intended to help us strengthen the system not only by improving the proceedings, of course, that is indeed part of the review, but also looking at the system in a holistic way. And that is not only looking at the court, but also looking at states, how we can improve cooperation by states, how we can galvanize political support from states, how we can increase protection for the court's independence and integrity. And this is not a hypothetical danger, but we have seen sanctions, we have seen other attacks against the court, and the court needs protection. So this is a court that can then deliver high-quality justice, but we need to help, and that is what the 384 recommendations of the experts were intended to do. But the second, a court worth having is also a court that is universal. And of course, many have referred to this today. Universality is necessary, is essential for effectiveness, is essential for legitimacy, because a court that cannot look at all atrocities equally is, of course, going to be criticized for selective justice and double standards. But of course, also within the situations under the jurisdiction of the court, this non-selectivity is also extremely important. But universality is not only about increasing the number of ratifications, although of course we do need that, but it's also about inclusiveness. It's about having sufficient representation of all regions of the world, having a sufficient and equitable representation of gender. So this is also about universality. It's about making sure that all citizens and nationals of the world are part of the court. And because universality, and that we have said this many times at the court, universality means respect and inclusion of diversity. Now, of course, a court worth having is also a court that has victims at its center. And we had a very, very interesting panel this afternoon, but many, many things were said about victims. The need to ensure sufficient access to victims to justice through appropriate outreach and information, ensuring effective participation, and of course, ensuring appropriate remedy. And of course, a court that is worth having is also a court that can work with others. And we had today a panel on the emergence of a system of justice, of global justice, an ecosystem of justice, where the court, of course, the proceedings of the court are very important, but are not the only ones. We also need and appreciate and recognize the proceedings of other tribunals, international and internationalized, but also we see also the increased number of states that are willing now to engage in universal jurisdiction. So it is through the combination of efforts that we can fight more effectively impunity for atrocity crimes. So we had a very interesting conversation about all this, but it was only the start of the conversation. Tomorrow, we will have the continuation of this reflection on a very specific theme, which is the contribution of justice to peace. We were going to have this Security Council area formula meeting tomorrow. There we can be able to to discuss this issue that is extremely important, because the court was created on the assumption that it would contribute to peace. And so tomorrow we will have an entire afternoon to discuss this. And tomorrow is not the end, because we will continue the reflection in Syracuse. We have here the Syracuse Institute that will hold these meetings on 12-13 October in Syracuse. And of course, they have worked with us together also to make this day possible as well. So thank you very much for all your thoughts. We apologize that you didn't have enough time to continue the discussions here, and all of you would have liked maybe to intervene more. But indeed, it is only the beginning of a reflection, because as we said, the commemoration is not just an event, it's a commemoration process that will end at the assembly at the end of the year in New York. So thank you very much. And now, remember, we have a reception at the Sputnik Lounge. So now we can continue the conversation there over a glass. Thank you very much.